Hello, hello, hello. It's Attorney Mike Grevlin coming to you from Chicago. As usual, we've got a weird mix. I need to thank Kristen and Mortimer Duke and probably other people that I can't remember right now. We're all over the board. I can't remember what's in there. Let's do it, shall we?
I need to place you under oath and ask you some questions. Ma'am, would you please raise your right hand? Maybe your other right hand?
This hand over here.
Oh, did you? Thank you. And you swear that the information you're about to give me will be the truth to the best of your knowledge?
Yes. Yes, ma'am.
Thank you, and you're welcome to lower your hand.
Ms. Mears, good morning. Ms. Mears, you're here for first appearance. You've been accused of 3 charges. You've been accused of 1 count of felony criminal mischief, leaving the scene of a crash involving damage to property, and obstructing an officer without violence. Ms. Mears, there is probable cause for these charges. I looked at your history. You have multiple prior arrests. You do have a ag battery case from about 3 years ago that was dismissed, but there are some concerning things in your criminal history. You're probably a candidate for a bond, but not a conditional release. But let me see if Mr. McDaniel has anything that I might need to know, or Ms. Bremer. Mr. McDaniel?
Your Honor, just life management needs to evaluate her.
Okay, thank you. Ms. Bremer?
Your Honor, the state requests a reasonable bond and no contact with Josie Scott.
All right, thank you. So, Ms. Mears, your bond's going to be $10,000 on the felony criminal mischief and $5,000 on the other 2 charges. The reason your bond is that amount is because of your history. Hang on, let me finish, and I'll try to answer your questions. And also because of the allegations against you. Supposedly, obviously I've not seen it, but according to the complaint, the alleged victim recorded most of this incident on her phone, and so law enforcement supposedly has a video of all or part of this incident. So, Ms. Mears, you do have a condition of no contact with the alleged victim. Your total bond is $20,000 cash or surety. And Ms. Mears, I want to ask the jail to get life management to evaluate you, but I'm not going to hold you past the time you can post a bond. In other words, if somebody gets there to post bond for you today and life management hasn't seen you yet, you have the right to the bond based on what's in the complaint. But if you haven't posted bond, life management will see you. Hopefully that'll happen today. Ms. Mears, do you have any questions?
Can I have permission to speak, sir?
I'm sorry, I couldn't hear you, ma'am.
Can I have permission to speak?
Yes, ma'am.
3 years ago, that aggravated assault was my husband cut himself on a utility knife, accused me, and I went to jail for what he did. State attorney dropped
I'm skeptical.
that. This time, a headlight got busted. I pulled right in my yard. The lady kept driving. The cops banged down my door. I got tasered 4 times. My truck got impounded, and I got sent to jail over a broken headlight. I'm already in life management. I'm already on medication.
The complaint has a lot of information that you obviously disagree with. The important piece of evidence in this case is going to be the video. Ms. Mears, you've got the bond I've set, ma'am, and you have the right to post the bond. You'll get to use the phone shortly, okay, ma'am?
So how much do I have to come up with to get out?
Your bond is $20,000. That means if you go through a bondsman, and if a bondsman charges you 10%, which they may charge you more, they may charge you less, but if they charge you 10%, it'd be $2,000. If they charge you 5%, it'd be $1,000. But that's something you negotiate with your bondsman. Any other questions?
Over a broken headlight.
No, ma'am. Over allegedly backing into someone behind you, trying to harm them, and then leaving, and then refusing to come out of your house to talk to law enforcement when they decided to question you. And then after that, allegedly,
Okay.
you resisted them.
I got assaulted by a police.
Ms. Mears, that's your bond, ma'am. Have a good day. After Ms. Mears, we have Kenyana Brown.
Sorry about that, Your Honor.
Oh, you can't control that. She just doesn't like me. That's okay.
Well, it's not, I mean,
It's okay.
told me about,
It's
and I mean, I've had
if I was
discussions
in
all
jail,
morning.
I'd be upset. If I was in jail, I'd be upset. And Miss Brown may have the right to be upset. I don't know. We're going to find out. So, Miss Brown, you're here for first appearance, ma'am.
If you haven't hit like and subscribe, I just want you to know that you're hurting Jack's feelings. Okay, I forgot that was from Natalie D. You can blame Natalie D for that clip.
She's not a victim. She's the perpetrator of threats, and she's a home wrecker for my client. You know, he mentions defamation. Truth is a defense. Truth is a defense. And if you act like a whore, then people are going to call you a whore. And that's what happened here. And you don't get to complain about it later on. You know, there are no credible threats.
Ma'am, are you a whore?
I object to the relevance of that, Your Honor.
All
right. What?
I'll tie it up real quick, Judge.
All right, go ahead.
You're not a whore?
Caused a serious injury to an individual or dog attacked a person, and they're requesting a summons and complaint. And among the options, as indicated, the statute, I'm sure Mr. Reed's going to quote it, speaks to the court shall rather than may. Mr. Reed, I'll allow you to go first.
Thank you, Your Honor. As to the GZ case, as far as the definition of a dangerous animal is where we start, it means a dog or other animal that bites or attacks a person.
According to
287, 321, sub A.
Right.
So that part of the statute is what applies here, dangerous animal. So the court has to make a determination. So that's the definition of dangerous animal. I believe the testimony was uncontroverted that the animal bit and attacked Cinda Miller. I think the argument that exhibits 1 and 2 are from rocks and falling on the ground. Just go to the weight and credibility that the court should give to the testimony of the defendant.
I was embarrassed.
I'll say no more on that. And when you look at the statute, and I'm looking at 287, 322, Your Honor, subparent 3, after a hearing, if an animal is found to be a dangerous animal, which I believe this falls squarely in the definition of dangerous animal. So check 1, it's a dangerous animal.
Haven't put me down yet.
And cause serious injury to, and I'm going to omit because there was no death, or death to an individual. The district magistrate, district court, or municipal court shall order destruction of the animal at the owner's expense. So the next question that the court looks at is the injuries. And 321 subparent E gives us definition. Means permanent serious disfigurement, serious impairment of health, or serious impairment of bodily function. It doesn't say permanent, but serious. Not being able to pick up a pen, dropping items, not being able to utilize your hand, having a doctor tell you there's not much we can do, to the point to her recollection, and it came in uncontroverted, that there's really nothing we can do. Those are dead nerves. She couldn't tell you the medical term, but she could tell you her diagnosis is, this is what you're stuck with.
You have gone to considerable effort and expense to try to make sure it doesn't happen again. But I will tell you, from the first moment I got this petition, I was concerned about shall. This is a dog fight, and I'm ashamed to hear your answer. This is inflicted by a dog fight. You can see the puncture marks. The other may have been a scratch. Even more, to consider this was done through her blue jeans. Powerful bite. And the question doesn't rise or fall on whether this happened on your property or in the shared easement property. She says it happened out in the dirt portion of the road. She says she could see the mailboxes from where she was. Her version is she parked only once, went to get the mail, got nailed, never got the mail. She denies that she ever moved the car or got out of it again. So the stories in that regard don't match. But what is clear is that she got bit. Now, we're all operating from the same choir book here. We're referring to the dangerous animal statute, which is 287321. As Mr. Reed argues, a dangerous animal means a dog or other animal that bites or attacks a person. So that's a dangerous animal. This dog bit and attacked. The defendant himself referred to it as an attack. And certainly Ms. Miller believes it was an attack that still haunts her to this day. Now, there are some exceptions. An animal that bites or attacks a person who is knowingly trespassing on the property of the animal's owner. That's not an exception. Simply walking over on someone's property isn't trespassing, and knowingly, even if she says she wasn't there, but even if she was, she doesn't know where the line is. And she wasn't there for any nefarious purpose. Another exception is that it attacks a person who provokes or torments the animal. She certainly was not tormenting the animal, and she did not provoke it. Provoke means to perform a willful act or admission that an ordinary and reasonable person would conclude is likely to precipitate a bite or attack by the animal. Well, for one thing, she didn't even know the dog was there. And so she wasn't doing anything that would cause a reasonable person to think they were going to get bit. So that isn't an exception either. And the third, that the animal is responding in a manner that an ordinary and reasonable person would conclude was designed to protect a person, if that person is engaged in lawful activity or is the subject of an assault. He is not. He is engaged in a lawful activity. It isn't like he climbed over the junkyard fence and got bit by the dog. He is out ready to go to work and greet his neighbor. So a reasonable person would conclude was designed to protect a person. Well, you didn't need to be protected from anything, or you were subject of an assault. So we're going there to the mind of the dog. The dog was protecting you. So is having a spring-loaded shotgun connected to your front door, or a hand grenade, or a landmine, there to afford some sort of protection. The dog was being a dog. The dog was being an Akita, which is a powerful dog with certain breeding and genetic history. So the dog was protecting you. That's not the question. Would a reasonable person conclude it was designed to protect a person if that person is engaged in a lawful activity or the subject of an assault? This dog protected you while your neighbor was talking to you out by the mailbox. The dog had previously bit the neighbor's dog. Her version was quite credible. You weren't there, so you didn't see what happened. And the very night before, the dog was out, and Mr. Eicher called, and you came and got the dog. Well, here the dog didn't escape under the fence or do anything to get out. But you have a powerful, dangerous animal. I find that the dog bit or attacked a person, and none of the exceptions under 287321 apply. So we go to section 322. after a hearing, which we just had, if the animal is found to be a dangerous animal, and it was. So from the very first day I saw this, the question was, what is a serious injury? Because I don't have any discretion. If the court finds that the dangerous animal caused a serious injury to an individual, district court shall order the destruction of the animal at the owner's expense. Ms. Davis goes on to say, well, if you find that it does not cause a serious injury, you may still order destruction of the animal or other options. The county ordinance speaks to that. That's what I'm struggling with the Colon case. I can't tell yet whether these people have serious injuries. They all got bit by a pit bull and they weren't very happy about it. But so a serious injury is defined. A serious injury means a permanent, serious disfigurement, serious impairment of health, or serious impairment of a body function or purpose. These bites to her hip and buttocks, she indicate, are still causing some discomfort and tightness and pain. But the injuries to her wrist, and she is qualified to testify about the nature of her injuries. I didn't need a neuropsychologist or a neurologist or an emergency room doctor to come in and tell me that she's in constant pain. It's not imagined pain, it's real pain. And the testimony, although it was hearsay, it was admitted, as they told her, we don't know if this is ever going to get better or not. And we can't do anything about these injuries. And you may need carpal tunnel surgery that may not repair the damage. So I find that she has a serious injury and a serious impairment of health or bodily function of a person, which leaves the court with no discretion. I find this is a dangerous animal which attacked or bit a person and does not fit any of the exceptions to that statute. I find that it did cause a serious injury or death to an individual. And Ms. Davis went on to think, is there reason to believe it could do this again? Possibly, yes. They've made every exception to try to keep the dog in there, but it could bite somebody on their property. So I don't have any discretion, which I was concerned about from the beginning. I don't enjoy this. This dog is going to have to be destroyed. It's going to have to be euthanized. Mr. Reed asked it be done within 7 days. You have 21 days to appeal this. So I'm going to leave you the appeal period, but the dog needs to be taken into possession of the St. Joseph County Animal Control. In fact, it was supposed to upon the filing of the petition, and I didn't catch it. So I take zero joy in this. I'm not going to do the sentence on the misdemeanor until this dog is transferred to the St. Joseph County Animal Control Office here in Centerville.
It must be immediately transferred.
Well,
Your Honor, the
Tomorrow.
defendant plans on appealing. We'd ask for no action to be taken for at least 21 days. Your Honor.
all right, we certainly won't do anything to destroy the dog, but the dog shall be transferred to the property of the St. Joseph County
warned
Animal
you.
Control by 5 o'clock tomorrow. You open till 5 o'clock?
Yes, sir.
This is a part of your family. You and your wife and your daughters love this dog. I'm not oblivious to that. But that with owning a big, powerful, protective dog comes responsibility. And this statute, when I make the findings that I make, compels me to order that the dog be destroyed. Doesn't compel me to like it. So the dog shall be transferred to the St. Joseph County Sheriff's Department by 5 o'clock tomorrow. I'm going to set sentencing in this matter, the misdemeanor. And I'm cognizant also of your missing your office hours.
Your Honor, animal control, this has to be between 9 a.m. and 5 p.m. tomorrow.
All right.
For staffing purposes to put the dog in the kennel.
And no action shall be taken regarding the euthanization of the dog until the appeal period.
Well, there you have it. It was depressing. I warned you. It's not all good times here. We can't just, it's not all calling people names in yellow. You know what I'm saying? That is interesting. Mortimer Duke sent that to me, but a lot of people had mentioned it to me. Yes, it's sad. In a rare moment of a lot of talk with Mike learning there, you get to see a judge go through a statute and contemplate it, and that's just the law. So he goes through the statute meticulously, and he goes through each element, and he makes his findings of fact. And I don't see how he can make other findings than the ones he did. They were correct. And once you make those findings, it's compulsory. That's the law. And the judge doesn't like it. He doesn't want to make the ruling. But he's got no choice. Unless he's making up his own law. There's plenty of that about. But Judge Middleton's taking his job seriously, and he goes through the factors as the testimony came in, and that's an inescapable conclusion. You could tell from the way he was giving his ruling there. He was trying to look for a way to save the dog, but as a matter of law, there just isn't one. So there you have it. I know my chat's a bunch of big dog lovers, but it was an interesting case, and there you have it. There you have it. Now, meanwhile, nobody cares when an inmate gets remanded, which is understandable. It's understandable because the dog didn't do anything but go along with its own instincts, and the judge recognized that. But that's the law. Yeah. If the family put the dog down. Now they've been ordered to turn it over. If they did that, they probably wouldn't be in any trouble, because that's ultimately what's going to happen if they can prove it occurred. But this family, they're going to try to appeal it and see if there's some way to get around it. I don't know that there is. He just read the statute. I don't see it. I don't see it. I think if they actually do appeal, they'll lose, and the dog will be put down. I don't know what to tell you here. It's not funny. I don't know what to tell. I know it's usually funny, but this isn't funny, and there's no. I didn't have something else lined up to soften this or anything. It's just that's what happened. It's a bummer. It's a bummer, and that's how it goes. But thank you all for coming out. I appreciate it. A lot of talk with Mike where you get to see people called 304s and then get really depressed. You're welcome. I'll see you all soon.